Hello, good afternoon. My name is Andrew Johnson, and it's my pleasure to welcome you again to this, now the second 5 Paper Buildings webinar. We've got 2 talks coming up this afternoon. The first was due to be from Julian Christopher QC on legal advice privilege. That's now going to be our second talk. We're going to begin with Miles Bennett from Chambers and Matt Bosworth from Russell Cooke Solicitors, talking about a case involving private solicitors and a local authority. So I'm now going to hand over to Miles and ask him to begin. Miles.
Andrew, thank you. Good afternoon, everyone. By the way, just as at the outset, there are some slides. You'll see them go voluminous, but if anyone needs the slide presentation afterwards or wants the slide presentation, if you get in contact with either Matt Bosworth or myself, we'll be able to provide that. So what's it all about? Well, in the words of Paul McCartney and Wings in Band on the Run, if we ever get out of here, we're all going to be looking for new revenue streams of work. And so what Matt and I decided to do was to put together this talk as an example of a new revenue stream for a firm of solicitors and how solicitors and the bar working together were able to deal with an area of work that the solicitors hadn't dealt with, in effect acting as solicitors for a local authority in a local authority criminal prosecution. And as the spoiler alert says on the introduction, the reason we're doing it is it has a happy client at the end of it. When you hear me every now and again saying, new slide please, Andrew, it's not that we're all power crazy and have just put everything on poor AJ. It's just that he likes to keep in control, as any of you who have met him, of running these seminars, and he feels excluded if he doesn't have a hands-on part to play. So AJ, new slide please. The reality, as we all know, is that local authorities have been slashed to the bone, not just in relation to trading standards departments, but also in relation to the legal department. And I don't know, AJ, if you have some magic button that allows all the bullet points to come in all at once. Oh, there we go. So the cuts don't just relate to trading standards officers, but legal departments, qualified staff, paralegals, etc. And sometimes, not always, but sometimes trading standards officers have found that the advice that they can get from their legal department, which, let's face it, has to look after everything from trading standards in the majority housing and adoption issues, can be a little questionable. And sometimes they're suffering from internal resources. And the reality is that when the local authorities finally come out of these restrictions, as we do, all the pressures on their finances and resources are going to double. And yet there will be cases where either they're victims or where they have a statutory duty where they are going to feel compelled as a local authority to prosecute. In this particular case, as we'll get onto when we deal with the background and the facts a little later, it was essential that a small local authority called Tendring, but basically we know them as Clacton-upon-Sea, having suffered what to them was a significant financial loss as a result of what they believed was dishonest and fraudulent behaviour by one of their suppliers, they were as anxious as possible to try and get their money back. At this stage, and before handing over to Matt as to what else and why solicitors became involved, once the proceedings were issued, the defence solicitors sent a 6-page letter having received the summons that can only be described as, quote, ballsy, quote, close quote. You'll be relieved to hear that I am not going to read out all 6 pages. I'm going to select 1 or 2 passages because it may stand as an example of exactly the type of letter not to send to a prosecuting authority who's just decided to prosecute your client. Its first paragraph starts in this way. The purpose of this letter is to invite you to review and abandon the prosecution that has been instituted against our client, a client of this firm. Second paragraph, This prosecution is misguided. For the prosecutor to bring this prosecution is an unnecessary and improper act. Well, there's nothing like getting on with your opponents at an early stage in the proceedings. And one of the complaints that they made was that, and a misguided complaint, was that it was outrageous for tendering to bring a prosecution when they themselves were the principal victims of the case. And they raised all sorts of threats of abuse of process, conflict of interest, such that it was necessary to sit down, evaluate and think, what else can we do? And of course, we hatched upon a plan. Well, if they say that there's a conflict of interest, the simplest way to resolve this is to see if we can bring in outside solicitors to do what solicitors do really well in the preparation and presentation of the case. I'm going to say next slide please, AJ, and I'm handing over briefly to Matt.
Hello everyone. My involvement starts when I received a phone call from the local authority, having been given my details by Miles Bennett, to have a free and frank discussion. When I say free, I do mean free discussion about the history of the matter, the state that the case was in, the position that the case was at the time of talking, and whether we could be of assistance in dealing with what was a very aggressive tack taken by the defence representatives, as you've just heard. I started off with the simple premise that lots of local authorities believe that outsourcing legal services in respect of solicitors, as opposed to counsel, may be something that you cannot do. And if Andrew, if you could hit the button again, you'll get the other points coming through. And quite simply, there are no rules against any local authority bringing in a solicitor's firm to run a discrete piece of litigation on behalf of the local authority. It's a simple client-solicitor relationship. So first and foremost, there are no rules there that can have any impact upon a local authority looking to outsource its legal services. It can free up those valuable legal resources, and this is something that we mentioned when we gave a talk to Trading Standards conference last year in Brighton, when people could gather in public for free. The simple point is this: local authorities have a multitude of tasks that they have to undertake, and this particular local authority, whilst it had in-house expertise to deal with such issues as matters of prosecuting fraudulent trading, it was not something that they dealt with solely, and they had all the other business of the local authority to take on board, whilst dealing with an exceptionally angry defence solicitors who were pushing at every point they could and deliberately trying to provoke and to upset those that were in charge of bringing the prosecution on behalf of the local authority for what was for them, as Miles has already said, a large amount of money. We therefore said that of course we could look at and review the documentation to hand, and then, and I'll come on to this later on in the talk, could take it through next steps. But the opening point was to say there is nothing against the principle of outsourcing. The point in its favour is that it frees up your legal resource to carry out the business of local authority, as opposed to becoming fixated upon one matter, which is what the defence wanted the local authority to do. And of course, it doesn't affect anything to do with the trial in and of itself, nor if you prove your case to the criminal standard, does it affect the fact that you can get your confiscation and or compensation order if you so wish to. There's also the final point, of course, costs. As long as your costs are reasonable and proportionate, and there are various tests which I'm not going to go into in front of a professional audience, then you can make an application for costs at the end of the matter when completed. And so that's really where we were on the initial point of view, which was, of course, we could assist. We'd be happy to assist, but first and foremost, we wanted to look at what exactly the history of the matter was and what the advices were And so from that, we'll go to the next slide, please.
And Chair, if you could put up all the bullet points, please, that would be really helpful. So what was the case about? David Eve was the sole director of a ticket agency called Standing Ovation Entertainments Limited. The local authority had a theatre and they decided to outsource, there's the irony in relation to this talk, the sale of tickets in relation to the theatre productions to David Eve. David Eve would sell the tickets either over the telephone or online, and at the end of each month he would provide an invoice to the local authority of the tickets that he had sold. And at the end of the particular run for that show, or not, www.worldwrestling. He would get the monies, or he would repay the monies back to the local authority, the monies he'd take. At the same time, he would charge commission at the end of each month, or a administrative fee in relation to each ticket sold. What he had done at the very beginning was to indicate to those dealing with the theatre for the local authority that although he wasn't member of a particular organisation called Star that would require him to ring fence the monies for third parties, he would in fact do so. And so for about 3 or 4 years, the local authority carried on believing that David Eve had kept monies in a separate account that could be returned to the local authority, as it was in fact their money for their tickets, as soon as they asked. And for the first 2 or 3 years, things went well. Although David Eve was mounting up debts, he was being able to move money around to pay the local authority, who was his major creditor, back at the relevant times. But towards the end of 2016, the local authority, who weren't perhaps as on top of their paperwork and bookkeeping as they should have been, realised that David Eve owed them 60, or the company did, some 60 odd thousand pounds. Now, for a local authority of tendering size, whilst that may not seem the largest amount of money, and that's relevant as to why it was a local authority prosecution a bit later, it was a lot of money for them, and they started panicking and they contacted Eve and they agreed to have a meeting in January, beginning of 2017. And because this is a small unitary authority, it was necessary to have one of their solicitors present at the meetings to make sure that they could see what was happening with where the money had gone. Now, the point about tendering is it had 2 qualified solicitors at the time. One was the head of the legal department for the whole district council, and therefore she had no ability to be able to manage either micro or macro a criminal prosecution. And the other one, who did have the ability, had been present at the meeting. And so, and this was one of the only decent points the defence ever made, well, there may be a need for this witness or this person to become a witness. And if she's going to be a witness, how can she have any conduct of the prosecution? So that was the background to all this. So when they had their first meeting, Mr. Eve said it was all very unfortunate. He was a bit vague about what had happened to the money. And this was not a case, by the way, where he'd been living it up with fast cars, women, alcohol and horses. This was a case where the business model that he was running was so naff and so rubbish that all his money was going on the advertising costs of click share advertising with Google. And the longer it went on, and perversely, the more tickets he sold, the more click-throughs there were, and the bigger fees he had to pay Google. There were 2 meetings in the January of 2017. At the second one, when he'd been asked to go away and provide a budget and also reveal to the local authority what the scale of debt in relation to the company and to others were, they had the meeting, and the night before, having had to be nagged, David Eve and Standing Ovations provided a breakdown which showed that in fact the debts were some 330 odd thousand pounds, of which by now, with Christmas and pantomimes and everything accounted for, the debt majorly to tendering district council was around about 125,000 pounds. Now again, in the great world of fraud, of which we all inhabit, that's not a large sum of money. But as tendering explained it to us in conference, it was to them the equivalent of the salaries of 5 teachers, maybe 4, and at least 2 further solicitors in the department. And therefore, they had a duty to try and recover the monies on behalf of the residents and the businesses in their geographical area. So they asked Mr. Eve to repay the money, and he said, well, funny you should mention that, but I can't. And they said, well, surely you've ring-fenced the money. And he said, it's been moved internally. And that was the only explanation that David Eve, until the trial, ever gave as to what had happened to the money. And when they said, well, they really needed the money, or they'd have to cancel the contract, David Eve said, well, the only way he could repay the money was A, that they continued the contract with him. So you can already see that this is, if it hadn't already been, inviting the local authority to get involved with a robbing Peter to pay Paul scenario. But what David Eve was accepting, although he didn't appreciate it at the time, was the only way that he could pay them back was to run the risk of increasing more losses, not just to the local authority, but to his other creditors, by continuing to trade, to try and trade out of the situation he found himself in. And as the final bullet point says, no monies were ever repaid, because when tendering inevitably cancelled the contract, within 2 weeks he had put the company into administration. Next slide, please, AJ. One of the important points in the case was David Eve and his wife, who was the company secretary, had taken out credit cards in their own names, and they paid them off every month, so not accruing any interest. But everything in relation to the business was paid through their personal credit cards. And what David Eve never quite understood, and didn't really understand, or pretended he didn't understand at trial, was that by paying off the personal credit cards, he was treating himself as a preferential creditor, and his wife, rather than paying back the likes of tendering district council. Because of course, the only person who was going to get into trouble if he didn't meet the credit card payments, and the only person whose credit rating was likely to be affected, was of course David Eve and his wife. As a sensible precaution, the local authority contacted the police. Well, you won't be remotely surprised that when they heard that it was only worth £125,000 and that there would be limited mileage in them, A, investigating, B, taking it on, and C, having regard to potentially getting a sixth of the pot in confiscation, the police simply wouldn't touch the case. You then had a local authority with limited staff and legal resources that I've said. One of them's a witness. You've made the decision taken to prosecute, which was done between the local authority carrying out their duties in relation to the Local Government Act and in relation to advice by counsel as to whether, one, there was a realistic prospect of conviction on the evidence, and secondly, and equally importantly, was it in the public interest to prosecute? And therefore, not surprisingly, the local authority had gone through exactly the same test and processes in deciding to bring the prosecution in relation to well, the standard test that the CPS would pursue. At the same time, they're being told erroneously that they can't prosecute because they're the victim. There's also the issue of disclosure, and there's also the issue that one of their lawyers, who would be the only one who could remotely have an impact on the case and run it, was a potential witness. And that's all for me for the moment. Over to Matt and the next slide.
So we come to the problems and solutions. Well, obviously, the what the defence wanted was very simple. They wanted the prosecution to be abandoned. They wanted the council to write an abject letter of apology to their client, and they would have looked for some form of costs as well. The solutions were actually quite straightforward and very stark for the local authority. They made a call, and it was some would say it was a brave call, but they made a call based on the following. They felt that they had a good, arguable case at law, and that they could prove to the criminal standard that Mr. Reeve had been engaging in fraudulent trading for a period of time, and that this was something that was right and proper for them as a local authority to carry out the prosecution to protect the local authority itself, and obviously to attempt to claw back those funds which had been taken and which were going to be lost in a sea of liquidation and debt recovery costs by civil practitioners. At this stage, I was asked to come in and to review the documents. The review of the documents was undertaken with no promises of carrying out or carrying on with the prosecution, but simply to see what my views were of the evidence and whether there was any mileage in bringing a prosecution or not, in my view. And that was carrying out, obviously, what would be known as the CPS test for public interest and to ensure that there was the correct evidential weight there to move forward with the prosecution. The review took place, and there was a great deal of documents and evidence to go through, and it took 5 days. And after the 5th day, I prepared my report, and my view was that there were grounds to pursue a prosecution, that I agreed with the view taken by the local authority and by council. We then entered into a period of a negotiation with the local authority as to what would be a commensurate hourly rate for undertaking the work. And let me be absolutely upfront with you all, it was certainly under what would be a normal private hourly rate for a law firm in central London. But it was something that was done bearing in mind, it was an exceptionally interesting case for me personally, fraudulent trading, and looking in on that world, especially somewhere where those involved in the practicing of fraudulent trading in the civil jurisdiction were very dismissive of any form of criminal proceedings being successful, and I'll come back to that a little bit later on as well. And also, of course, because of the way that the defence had set out their stall in attacking the process and the procedures, which again was something that I found fascinating, having been involved in prosecution work and bringing private prosecutions on behalf of clients, both individual, corporate and regulatory, over a period of well over 15 years now. I was intrigued to see that they had some very bold statements regarding who could and who couldn't bring or commence prosecutions. And so it was something that the defence certainly were not expecting, in as much as when they got a letter from me being sent out to both them and to the court saying that Russell Cooke had been instructed to undertake a review of the proceedings and were now instructed by the local authority to carry out the prosecution on their behalf, and that if basically anyone had any problems, they could come and see me. To put it simply, the prosecution was outsourced. There was some initial views taken by the defence representatives, but I'm glad to say that these changed quite quickly when they reviewed the law. So again, what can the solicitors do for you on a private prosecution? We can look at the independent assessment and the merits of the case. Those solicitors who actually have got a record and a history of bringing private prosecutions can do so by taking the clients, local authority clients, through the case. And there's always weaknesses. There's always going to be points of weakness on every prosecution that is brought. It's the way that it's seen over and around, and it's the way that you deal with things over a number of years and how you work with it. And the main weakness on any form of criminal trial is unused material and or disclosure, because it's just simply put, I speak as someone who also defends regularly as well. If you may find that your client has some rather harsh facts to deal with on the evidence, then you look to the process and the procedure to see if there are any weaknesses there which you can exploit. That is your job. And I think as prosecuting solicitors, we understand that as well. And we understand how best to deal with defence solicitors and to take the personal sting out of matters where possible, and to deal with things in a professional manner. We also, of course, again going back to the other point, free up the local authority to deal with their ongoing business, and we can deal with the conduct of the litigation and the case preparation with counsel, whilst reporting in on a regular basis to our clients, apart from those who are witnesses. And finally, of course, we act as that buffer between the local authority and the defence representatives. If there are any issues, if there are any questions, we can deal with them properly and proportionately in the place of our local authority clients who can go about their business. And that's where we got to with this case M3. So next slide, please.
What I should have said at the outset, and Matt's already covered it, but the charge that we had decided to embark upon was fraudulent trading in relation to the Companies Act, not in relation to running the company for a fraudulent purpose, but in relation to creditors, because when we looked at the accounts and when we looked at the invoices and we looked at the money that was going out and in, it seemed clear to us that there came a point in time that you could almost identify as to when it was that the company passed the point of no return, in reality, in being able to meet its debts. The real issue in the case, and I highlight this because of the first bullet point on the screen, is the sole issue when the defence had stopped moaning and writing 6-page letters. And by now they'd silked up, as it were. I don't think it would be appropriate for me to say who the defence solicitors were or the silk on this forum, but if you give me a call afterwards, I'll happily tell you who it was on both counts. But bearing in mind the only issue in the case, I always do that because it's great to see AJ put his hand above his face in a 5PB webinar. But they mounted an application to dismiss. They also threatened an abusive process on the basis that we couldn't possibly be the prosecutor, that's the local authority, if we were the victim. Well, you don't have to study much law to realise that that's a particularly bogus point. Well, one of the challenges in this case that Matt and I found was some of the points the defence were coming up with. You had to go and lie down in a darkened room for about half an hour with a cold towel above your head to come back and think, am I just going mad, or are these points really, really rubbish? What have we missed? So the defence had started bully boy tactics on the defence with a view to try to get them to drop the case. Then they claimed that it was an abusive process, which, funnily enough, they never decided to pursue. And then they dealt with an application to dismiss. And the only thing that Matt and I can really, really remember about the application to dismiss was A, it was too long. B, it was held last summer on the hottest day of the year when we were in Chelmsford, a stone throw away from Cambridge, which recorded the hottest degree of 38.4 or whatever it was, and the air conditioning wasn't working. The only joy about that hearing was that the silk, although without his wig and robes, was in his silk jacket and his silk waistcoat. And forgive the pun, he was melting away, as were his entreaties that there was no basis on which a jury could ever convict of dishonesty. The hearing lasted the best part of 2 hours. The judgment lasted 7 minutes. It was inevitable that this case was going to go to trial. We then had a series of disclosure requests, and one of the more difficult aspects that Matt had to deal with was the liquidator in trying to get information out of them. Dealing with the defence was still hardball from the points of view that they were taking, and we were trying to prepare. And because the local authority were concerned about the prospect, because let's face it, we all know that when you go into a jury trial, you've no real idea what the outcome is going to be. And we've all been in cases where we've prosecuted, where we've had strong cases, and a jury have acquitted. We've also been in cases where they've been quite weak, and the jury have convicted with aplomb. And in this case, Matt's assessment independently, and the investigators, and mine, was that this was a strong case on dishonesty. And where we were helped in case preparation was Natalia Segro from Chambers, because this was outsourcing in all different ways. What we said to the local authority was, we're going to need to prepare schedules. There is no point in the solicitors running up costs preparing schedules. There's no point in paying me to do the schedules. Can I introduce you to someone younger, and yes, more intelligent, obviously, and yes, cheaper, that magic word for all local authorities, cheaper to prepare the schedules. And the importance of that in raising invoices and when they were paid was that became one of the most important planks in presenting the case to the jury on behalf of the prosecution in the trial and in relation to cross-examination of the defendant when he gave evidence. But because the local authority were being responsible, they even instructed Matt and I to make an offer to the defence. The fraudulent trading period covered about 2.5 years. And because they had a view compensation of the money that they'd lost, they said, look, pick a period of 6 months towards the end, go back to the defence, tell them what they owe us in relation to the money, and then say, we are prepared to settle this now without your client, who's a man of good character, running the risk of either a custodial sentence or, more importantly for him, a conviction of dishonesty. If he's running his own business, using other people's money as a ticket agent, if he gets a conviction for dishonesty, it is inevitable that, subject to him being struck off as director, that no one is going to want to touch him. This is your client's opportunity to pay most of the money back, not all of it even, and not run the risk of a conviction. Next slide, please, AJ. I then had the dubious pleasure of having opened the case, calling as my first witness Patrick Matthew Bosworth, whose sole role in this case had been to go to the liquidators and get the file. And because the liquidators weren't playing ball, Matt did the statement saying, here's the file, I've served it as or disclosed it as unused material. And such was the nature of the way that the defence approached this case that Matthew became a fully bound witness. I worried when I saw him take the oath, but he got through it unscathed. And we called him as a first witness, and we explained to the jury that the only reason he was being called as the first witness is because A, as far as we could see, he had absolutely nothing to do with the real issues in the case, but B, the defence wanted to ask him questions. We then called the case investigator, Claire Lewis, who was absolutely brilliant. She had done this case on the investigation entirely on her own from start to finish. Oh, and the other complicating feature that I thought I'd wait till now is by the time we'd issued the proceedings, the financial investigator who'd been doing the hard graft, he'd now died. So we then had to shop around for a new financial investigator to take over the case. There were the liquidators, or not the liquidators, the administrators were called. And this was a case where in reality, the time estimate was 5 to 7 days, 7 on the outside. Because of the way in which it was defended, it took 13. All good for those of us who are being paid refreshers and for the solicitors, not terribly good for the defendant. I've put calling character witnesses here because it's a thing that I often return to in trials. And this was a classic example of when the defence should not call character witnesses. Far from providing good character evidence, they revealed really a side to the defendant who really hadn't kept anyone that was close to him in the loop of what was going on. And when he did call his accountant, as much as a character witness, the accountant accepted from me when he was cross-examined that he had told Mr. Eve that he ought to get in contact with all his creditors way before he had done to say, hey, listen, guys, I'm suffering some cash flow issues here. I know many of you who are watching this will find this slightly ironic or pot versus kettle coming from me. But if Mr. Eve could lose 10 words in answering a question rather than 1, he would use 10. And so we moved on to the verdict, and bearing in mind, and I returned to the defence's letter from just after the proceedings had been issued, which said this: the procedural impropriety of tendering being the prosecutor in the case, the disclosure and privilege indications for legal services, the evidential weaknesses, all of these issues which would have been apparent to an independent prosecutor doing its job properly would have given a prosecutor pause for thought. That was one of the paragraphs in their 6-page letter about why we shouldn't be prosecuting. Well, I said the story had a happy ending. It does. Jury by a majority of 11-1 convicted, and the case was adjourned for sentence and ancillary orders. Now, we haven't done the sentence yet, because of course it just was about to come in at the time that the restrictions were all imposed on us. But as Matt will deal with in more detail in a second, and what we were looking for, the ancillary orders, well, there was the issue of confiscation versus compensation. And more importantly, by now the insolvency service and the liquidators and saying, I'll tell you what, if you get a conviction, save us the trouble, ask for him to be disqualified under the Directors' Disqualification Act for his conduct in the company. And now over to Matt.
Thank you. So what did the client want from this case? Well, first of all, they wanted to get a conviction in the criminal court, because that's the course in which they started. But they also were very much pursuing this remedy because they felt it was their only way in which they were going to recoup any of the monies which had been taken from them in a fraudulent manner by Mr. Eve. There was a lot of talk of the differences between confiscation and compensation, and to paraphrase Mr. Bennett, we had to reiterate at several different stages to our clients, the local authority, as we always do. There are 2 C's in confiscation, and the first one is conviction. Once that we worked through from there, and once that we had reached the stage of carrying out having the charge proved before a jury, I should also point out that by this stage, the defence solicitors had ceased to be instructed, and the Silk was carrying out the defence of the client on a private fee-paying basis, on a direct access basis, notwithstanding the fact that that particular Queen's Counsel did not have a litigation ticket at that stage, but that did not cause him or his client any issues. So we came to the position following the case where our cost schedules were put forward, and were put forward on the basis that they were just and reasonable. Just and reasonable because if we go back to the start of the matter, we had worked out what was the suitable hourly rate for officers of the local authority, and we had worked within those parameters. We were not trying to pull the wool over anyone's eye by saying this is some fantastically strange and difficult prosecution that has been brought by solicitors in private practice because we have the little grey cells that can work quicker and faster than anyone within a local authority. Far from it. We are carrying this out because we have a proven track record in running private prosecutions for various clients, and this is a perfectly straightforward prosecution, but one that's being defended in a very interesting manner. And so that's why our costs were put forward and not questioned by any party. There was a change of approach by defence once the verdict of guilty had been passed by the jury, and that was that they were seeking to ensure that they could come to a view of paying an agreed amount between parties in relation to those funds that had been wrongly taken and disposed of by Mr. Eve, without going down the route of a proceeds of crime application. That is still extant, and it's still to be finalised because of the outbreak of COVID-19. And so there's not much more that I can say about that at this stage. Apart from to also say that our clients also instructed us to ensure that there was a director's disqualification applied for in these proceedings because, of course, Mr. Reeve was the director of the company when he carried out the actions that he was found guilty of. This was, on a personal note, apart from the fact that it's not every day I get questioned by Queen's Counsel who seems to want me to go through the entire law of disclosure within a 10-minute time frame. One of the most it's very hard to find the exact words, but one of the most explicitly aggressive defences that I have seen run by any firm of solicitors within England and Wales, and one that I feel was done because they saw at the very heart of their client's case there was a gaping hole, and that gaping hole was the fact that he was guilty of the charges which were being levelled against him. And so at the end of these proceedings, although it took a very long time to actually get the trial up and running, to get things through, and because every point was taken, but every point was battered away because we, and that is solicitors instructed and counsel, had and have been involved in bringing prosecutions for over 15 years, longer than that, actually over 20 years now, that we ended up with a very happy client who understood that the work that they'd done had been properly sought, properly thought, and properly executed. And that was the end of the matter as far as Russell Cooke were concerned. And I'll hand you back to Miles now for the final part from him.
I'm only going to deal with this very briefly because we're coming close, if not past our time limit, and some of you will want to learn some proper law from Julian in a moment. All I want to say with this, the reason why we did this talk is I was speaking to Matt about new forms of work, and he was saying in relation to the Trading Standards Conference, well, I go down there and I see fact, what's the point of me going there? I might as well stay in London. I say, well, hang on. And this was true. The more I had travelled around the country in the last 2 years doing trading standards cases defending, the more I found that in the north in particular, local authorities, even county councils, were outsourcing to specialist solicitors in their locality or in the area to carry out the prosecutions. And so when we agreed to put on the talk, Matt hadn't been instructed in the tendering case. It was a pitch to trading standards and local government authorities. By the time we started to do the talk, Matt and Russell Cooke have been instructed, and it shows there are always new revenue streams out there that people traditionally have thought, well, we've never done that type of work and it's not for us, or we won't be able to do it. I agree with Matt in relation to costs. He had long discussions with tendering, whose only concern at the beginning was, gosh, this is going to get expensive. Then it became, well, why don't you tell me what you're charging out at local government rates, and I'll see what I can do. And that's why, as Matt said, when our cost schedule was handed in, surprise, surprise, no one quibbled over a shilling, a penny, or a cent. I hope you found that interesting. If you need the slides or any feedback, you can contact me at mb@5pb.co.uk or the Chamber's number, and we will make Matthew Patrick Bosworth's email address available as well. Thank you very much for watching and listening. Over to you, AJ.
Miles, thank you. We have had one question come in during the course of the talk, which is this. Is there any risk involved in promising to drop a prosecution in return for cash? Could there be in some circumstances?
It depends on it really rather depends. It's a question of fact and degree. I have, over the period of years when defending, often approached local authorities with solicitors and said, look, we don't think your case is very strong. This is all really rather embarrassing, and it's going to cost you a fortune, and we're going to take every point. However, we are aware that you have a statutory duty to examine this, and we think you've been led up the garden path by your complainant. The way perhaps to deal with this is for us to, you tell us what your costs are, and we'll make a payment for your costs. And if necessary, and if the client's prepared to do it, would accept what they used to call as a home office caution. I think the biggest problem for local authorities is, do I think it could go wrong if you're offering it? I suppose the danger if you're on receipt of an offer is if you get too sucked in, does it amount to an abusive process? Put it like this, if you go down that route and then you decide to increase the amount of money that you want, and then the other side say, well, that's not what we originally talked about, then I think if you were to go back on a promise that you were prepared to do, or even not a promise, and in an unofficial, yes, I'm sure this can be resolved, I think you might get hit by an abusive process point. There.
The next two questions are for either Miles or for Matt. The first is, how did the council gather evidence? I presume they didn't use any powers. Miles, I'm afraid you're talking whilst on mute.
I can help if you want.
Yeah, no, I'm all right. Matt, you can do the next one because I know what the next question is.
Right.
Yeah, you see. How did they collect evidence? Well, firstly, what they did was because most of the witnesses were in effect council employees, they were able to go to the corporate and hospitality team that were in charge of the theatre and able to take statements producing records of contracts, etc., that they'd had with David Eve for a period of time, and also various conversations they'd had, and also meetings in relation to performance. So that bit was really quite easy. The second thing was the financial investigator, to start with, had used his pocket powers because there was an issue of potential money laundering. Now, we decided not to put that on the indictment because we didn't think that it was going to add anything to the fraudulent trading. But in the course of the investigation, they'd used their powers as the financial investigator for Pocket to get bank statements, credit card statements, and so on and so forth. And so they were able to piece together what was going in and out of the various accounts that David Eve and the company had, and they were able to reconcile it against invoices that either Eve had provided for his administrative fee, or indeed that they had provided in relation to ticket sales for their money's return. So in reality, it was relatively straightforward. We also had some assistance from one chap at the liquidator who was very helpful for as long as he was working at the liquidator, and then became, as Matt discovered when we were trying to get things out of them and eventually threatening them with witness summonses, became very unhelpful. But most of it was tracing through invoices, shows, ticket sales, what was going in the bank accounts and credit cards, and what was coming out. And so the answer to AJ's question is, apart from the application to the court, no one needed to use any special investigative powers. We decided not to go and raid David Eve's home and seize things. It just wasn't necessary. We had most of the emails that we needed in any event. The only other thing that we did do, right at the beginning, before even I had been instructed and Matt was instructed, as a holding gesture, the local authority took out a restraining order against David Eve. And after about a year or so, the court where it had been taken out said, what's happening? There doesn't seem much progress. If you're not about to bring proceedings in the next X weeks, we'd like the restraint order lifted. And because the only assets were what he was earning and a rental property and the matrimonial home, we agreed for it to be lifted. Now, when we found out that he was paying privately, we had a series of discussions about whether we thought it would be appropriate to try and argue for a new restraining order on the grounds that he was dissipating funds by paying his lawyers. But we decided that because he wasn't eligible for legal aid, because of the house and the rental flat, he'd have had to pay privately anyway. And we decided that as there was no evidence that he'd be spending it ridiculously on, as I said, cars, horses, women and song and wine, we decided that it would be overkill. And it was a long, in trying to be fair to the defendants, but at the same time try and keep hold of any assets that there might be left for either a compensation order and costs or confiscation.
Thank you very much, Miles. Matt, the final question is this. How would you introduce yourself to a council in the first instance? I'm sorry, can you hear the question now? Matt, are you able to hear my question?
Try me.
I can't hear anything.
Okay. Well, I'll deal with the next one. AJ, read it out again.
How would you introduce yourself to a council in the first instance? Is it just a case of traditional networking?
The answer is probably. It was slightly unusual in this case because, as I'd already been internally instructed before the issues really crystallised, it was much easier for me to say, well, look, okay, you're going to have to outsource. Here's the firm of solicitors I'd recommend that you should use because they've done lots of private prosecutions for Federation Against Copyright Theft. And more importantly, they're really on top of how to deal with unused material and disclosure. And that was really the primary issue for the local authority. But there is absolutely nothing wrong in good old-fashioned marketing techniques. You can either contact a trading standards department and contact the head and say, look, I know you use your internal legal services, but if you ever want to chat and you ever want either on a particular case or a project or anything like that, some assistance, please get in contact. Or you could go straight to the legal department and say, if there's ever a case where you become slightly overstretched in relation to your resources and you want to outsource, then you here's our CV, etc. This is what we do. We can help. It's a mixture, but I wouldn't be frightened of cold calling. It clearly worked for the firms that were doing the prosecutions that I was defending in the north, and as I understand it, that was really how the contact had emerged. So, yeah, emails, phone calls, the normal stuff.
Right. Well, thank you, Miles. Thank you in particular, Matt, for joining us. And thank you to everyone for watching and listening. And we will be back with another webinar next Thursday at 3 PM. And we hope to see you join then. Until then, please stay safe and take care.